Hello, everyone. This is Tom Fox, and I'd like to welcome you to episode 223 of the FCPA Compliance and Ethics Report. We start off the new year with a visit with Tim Peterson. Tim's a partner at Murphy & McGonigal in Washington, D.C., and we both have a joint love of soccer, or the worldwide sport of football. Tim visits with us about the new superseding indictment, which was issued in December against FIFA officials, and talks about what U.S. companies who have been involved with FIFA or worldwide sports organizations such as the Olympic Committee or the IAAF need to do in light of these new developments. The episode comes in at just over 20 minutes. I hope you enjoy it. Thank you very much for listening. Hello, everyone. This is Tom Fox. I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. I have back with me Tim Peterson. Tim is a partner at McGonigal and Murphy in Washington, D.C. Tim, looking at your the website today, I saw that you have a picture of yourself with a beard that is new on your website. So I wanted to acknowledge you for that. Very Movember-ish and all that. But thanks a lot for taking the time to visit with me, and welcome back.
Well, thanks, Tom. Good to be here. Yeah, I think I'm the last male in the United States to get on the beard trend. So the trend is officially over.
You're not a trendsetter, you're a trend ender.
Yeah.
Okay. Well, I asked Tim to come on and visit with us because we had some new developments in the FIFA corruption case and really the greater international sports world. I visited with Tim about corruption in FIFA before. He's written and spoken extensively on this. And so I asked him if he'd come back specifically, Tim. I wanted to jump right into it. There was something called a superseding indictment released a couple of weeks ago, and new arrests of FIFA officers or officials. I'd first like to ask you, for my listeners who are not familiar with United States criminal procedure, what is a superseding indictment, and how does it relate to an original indictment and indeed the criminal process?
Sure. Well, very simply, the superseding indictment is an update to the previous indictment. The indictment, of course, is the formal charge that the prosecutor brings against the defendant. It includes all of the allegations, and it's brought after the prosecutor has presented his or her evidence to a grand jury. The grand jury actually votes to approve the indictment. The superseding indictment comes about when the prosecutor obtains more evidence about additional charges or additional defendants that are going to be added to the case. So just because the original indictment is handed down doesn't mean the prosecutor has finished the investigation. The investigation continues, and if more facts or defendants develop that are appropriate to add to the case, they return a superseding indictment from a grand jury.
Tim, we had, I thought, obviously the first round of arrests in the FIFA case were quite dramatic, but we had some equally dramatic arrests this week where FIFA officials, or not this week, but last month rather, where FIFA officials had flown to Switzerland for additional meetings. They were arrested at the hotel. We had one FIFA official arrested on a cruise ship when it docked in the United States. So very high profile, but what were some of the things that you saw in the superseding indictment, or new and different, or did it just build on what we saw last May?
Well, I think it was interesting that from a legal point of view, there really wasn't anything new. They charged they took the same approach that they took with the original indictment, which was what we call a RICO charge, generally supported by a number of other underlying charges. And a RICO charge, as you know, is an allegation that you have a racketeering influenced corrupt organization. That means an organization or an enterprise that is being run in a pattern of racketeering. In this case, the racketeering they're alleging involves a number of different charges, including bribery and money laundering, and other related types of charges. It's interesting that this still is not technically an FCPA case.
Right.
The RICO charge is really the overriding approach to it.
Right. Now, these arrests really seem to focus on corruption of FIFA officials domiciled in the Americas, with either South America or Central America. And the other thing that I thought was interesting is, in large part, it revolved around broadcast and television rights, which were granted to these officials who then resold them to others. And there seemed to be a fair amount of, at least in the allegations, of corruption around the sale of these rights. And I really wanted to use that as perhaps a springboard into one of the things that you have been really at the forefront of talking about, which is that sports companies in the United States need to think about the FIFA case and take a look at who they're doing business with. Can you sort of explain how all that ties together?
Yeah, sure. You know, when the FIFA case first arose this past spring, one thing I was looking at, and my partners as well, was why those allegations might have surfaced or what might have happened to lead to those allegations. And generally speaking, when you've got corruption allegations, there's a structural issue. There's something in the way that the organization is put together that leads to the potential problems. You know, one thing we're always advising clients on is how they can best structure their organizations and their controls to minimize their corruption risk. You're never going to get rid of it, but if you have a proper structure in place and you have a governance system that looks for corruption risk, you can minimize the problem. In the case of FIFA, we tried to look at what structural aspects of FIFA and what governance issues might lead them to a heightened risk of corruption. And an interesting thing from our point of view is that the characteristics we saw at FIFA might also be present at other international sports organizations. Doesn't mean they have problems, but it means they have similar heightened risk of corruption.
And then one of the things that obviously from the first indictment, there was a sportswear company in the United States. It was identified only as Sports Company A. But it looks like there were payments made around the furnishing of apparel, furnishing of shoes, in addition to these television or other broadcast rights. Anything that American companies who are in that business of supplying shoes to national sports federations or national soccer federations or national teams, is how would you advise a U.S. company to think through that process now?
Sure. You know, given that there's now a spotlight on this type of
Sorry for those technical difficulties, but we are now back with Tim Peterson. Tim was about to tell us some of his thoughts that he and his partners had come up with around what U.S. companies might do in response to the original FIFA indictments. And, Tim, I'm going to ask you if that has changed based upon the superseding indictments, and then maybe we can get into the greater sports world. But back in June or May even, what were you counseling clients in the sports marketing or sports apparel industry, or really anyone else who did business with FIFA, to do at that point?
Sure, Tom. You know, as I think we mentioned last time, one of the issues here is that when a government enforcement official finds something that they think is a problem in one particular area or with one particular fact pattern, they're going to look for other cases with a similar DNA under the assumption that they'll find other problems or other things that they have issues with. So because of that, companies that have dealings with FIFA in particular and in the sports world generally need to take a good hard look at their compliance systems. You know, first of all, what they need to do is understand what their compliance systems are relative to sports marketing and check whether or not those are actually working in the manner they're supposed to work. And for a lot of companies, that's going to take a little bit of work. First of all, because a lot of companies involved in sports marketing may not have robust compliance systems. It may not be something they're used to. Secondly, organizations involved in sports which do have more familiarity with compliance they may be familiar with compliance in their core business, be it retail or banking or what have you, and they may not have focused on compliance in something like sports marketing, which is really ancillary to their core business. So I think first and foremost, they need to review what their systems are, if they have them, relative to sports marketing. And then specific to FIFA, take a look at what their historical track record is with their relationship with FIFA. Take a look at existing contracts and do another level of due diligence on those relationships, even the ones that are perhaps no longer active.
Tim, you said something really interesting there, and I might want to drill down a little bit deeper into this because it's something that's, I think, very important. And if I might rephrase it a little, if your risks change or your risk profile becomes different, even if you're in one business, you need to be able, your compliance program needs to have a flexibility and nimbleness to tilt over that way, because many of the companies that would have done business with FIFA in terms of sale of television rights or licensing and hospitality rights, their core business was not that. So I don't want to suggest any of these companies did anything askance, but of a soda product company, for instance, or a shoe company, for instance, or a shirt company, for instance, or a credit card company, for instance. Their core business is selling those products, and they may not have paid attention to the risk in marketing. As you suggested, how does someone in a compliance function get their arms around something like that, where the risk changes?
Well, I think something any good compliance attorney would advise is that companies constantly reevaluate their risks, conduct new assessments, and adapt their compliance procedures as the environment adapts or even as their business changes. So this is definitely a change in the environment. And I think that companies and people within companies responsible for compliance need to take that into consideration and do a complete review of where their risks lie. The other aspect of it, too, is smaller organizations in particular just may not be used to this, and it may not be something they've even considered. And that's going to be a much bigger haul for them. Companies that are used to this and do regularly revisit their risk profile, this is just another piece of the ingredient they're going to have to throw into the mix, and they should be used to it, and they should be able to carry that out. The smaller organizations, they're going to have a little more work to do.
Tim, last June, you and several of your partners put out a short white paper entitled "Should the IOC Worry About the FIFA Fiasco?" and you put in some of the revenue for marketing numbers, and they were just astounding for FIFA. From the 2014 World Cup, it was $2.4 billion in the sale of television rights, $1.5 billion for the sale of sponsorship rights, and $200 million for licensing and hospitality rights. And I would have said those were just outstanding, but later on in the same paper, you talk about the numbers generated in the London 2012 Olympics of over $8 billion in marketing revenue to the IOC. Obviously, we have the 2016 Olympics coming up. So what would you counsel a company that has not been involved with FIFA but somehow is involved with the IOC or the upcoming Olympics because of these numbers and increased scrutiny?
Yeah, well, I think the advice would be very, very similar. Like I said, government enforcement officials tend to look for similar fact patterns, and the Olympic Committee, if you just look at the way it's organized and the way the games are awarded, it's got a lot in common with FIFA, and I would expect a certain degree of scrutiny to be going on in enforcement circles around the world into the way the games are awarded and the way the arrangements are parsed out to companies and to marketing firms. If I were an organization doing business with the IOC, I would definitely put a heightened alert on any kind of transactions we have with the IOC and give it increased due diligence. The risk factors you see at the IOC are very, very similar. You've got enormous economic rewards, and for many of them, it's a winner-take-all environment. Only one company is going to get the rights to do X, Y, Z. There's a small group of people making decision-making, and some of the decision-making is coming from people and organizations in regions with relatively elevated corruption risk.
And the other thing that you made very clear in the paper is the governance structure. Obviously, in FIFA, we focused on CONCACAF and CONMEBOL and the regional sports authorities. But with the IOC, we have national Olympic committees who may enter into their own independent sponsorship deals with teams and athletes, and that presents an additional level of risk, not new or different, but it puts in another level there that I think people need to consider as well, because outside the United States, these national Olympic committees may become close to state-owned enterprises.
Absolutely, and that gets into FCPA territory, of course, although, as we saw with FIFA, FCPA isn't necessarily the only law that people need to be concerned with. There's the national level Olympic committees in all these various countries, and there's also the team level. Some of these Olympic teams themselves for various sports have their own individual sponsorship agreements. So in some ways it's highly centralized like FIFA for the large awards. In some ways it's very decentralized. And companies are going to have to do a lot of work to understand what their relationships are with the Olympics.
One of the things that I've always been fascinated with in the realm of sports marketing is it seems to be murky. And if you think about some of the players in the U.S. Sports apparel industry, there's always characters floating around, whether it's a guy named World Wide Web or, others. And I just wonder if that sort of murkiness or non-transparency or opaqueness also extends out into the international realm. And any thoughts along those lines?
Well, you brought up a good word there, transparency, and I think transparency is an issue with a lot of these international sports organizations. I don't know about murkiness, but it's certainly something where when you're not sure exactly who you're dealing with on the other side, that throws your risk factor up significantly. So one thing companies need to do is increase their due diligence, and particularly in the sports world right now, given the focus on it and given the general lack of transparency. And that's particularly important when you've got third parties involved, which I think we saw in the FIFA complaint. There was a good degree of involvement with third parties. Companies really need to do deep dives into who they're dealing with on the other side and not simply accept that lack of transparency as a given.
Tim, I had tried to talk about the 2016 Olympics and U.S. companies on the FCPA risk, or at least potential risk regarding the physical plant, the construction of sites, the building of roads, the things the government had to do to get ready for the games. You and your partners have really talked about the Olympics, the sporting part of the Olympics as a risk, an area of risk that needs to be evaluated. But we've seen other sporting groups have scandals here in the last couple of months. Obviously, the doping out of Russia, and then the award of the 2021 World Track and Field Games to Eugene. It does seem there's a lot of scrutiny in areas that may not have been as transparent as other businesses. Is that your general observation as well? Yeah,
I agree. And you brought up the IAAF, and for those who aren't familiar with it, that's the International Association of Athletic Federations, the International Track and Field Group. There's been a lot of scrutiny into a couple areas with them right now. One is doping, as you mentioned, and the other is the award to Eugene of the World Championships. What you have there is a very similar setup, at least, to FIFA and to the IOC. You've got a large organization with member institutions in various countries, a council which votes on bidding for a lucrative contract for World Championship games. The allegations sound similar. That one's still very much a live issue. Not a lot has come out on it yet, but it's going to be one to follow very closely. And I think that just goes to the idea that organizations generally involved with international sports need to take a look at what they're doing in that regard.
Well, Tim, I know a lot of lawyers who have thought about this and talked about it, but you and your partners are one of the very few groups who are putting thought leadership out there around this topic. So kudos to you guys for doing this.
Thank you.
You're absolutely right. When the government starts to look in one area, and as big as this has been, and with the 2016 Olympics coming up, I hope anyone involved in that will pick up the phone and call you, or at least email you to get some counsel and guidance. And if they wanted to do so, how could they contact you via email?
Well, yeah, great. We're hoping that we can help clients get out in front of this, and even if situations arise and problems come up, if you can show you've been in front of this, you're often much better off. Anyone is free to get a hold of me at my email address. That's tpeterson@mmmlawus.com, or you can Google me, Tim Peterson at Murphy and McGonigal. I'd be happy to talk to anyone.
Well, Tim, I greatly appreciate you taking the time to visit with me. Sorry for the technical glitches, but I think this story is going to be ongoing, and I hope we can continue the conversation.
Tom, I hope so. This will be very interesting going forward, and we'll see where it goes.
All right. Thanks a lot.
Thank you. Bye.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance and Ethics Report. I'm developing my next mailbag episode, so if you have any questions, I would appreciate if you'd email them to me at tfox@tfoxlaw.com. Also, if you could go to iTunes and rate this podcast, I would greatly appreciate it. Thank you very much for listening, and I look forward to visiting with you. In my next episode, I'm going to look at some of the significant developments of 2015. Thank you very much.